The matter before the court is Lincoln 24-235, estate of Patricia Spofford. And if counsel who will be arguing would introduce themselves by saying their names for the record, together with the party that they represent.
Good afternoon. Chris MacLean. I represent Michael and Peter Zani.
Mac Walton. I represent Appellee St. Jude Children's Research Hospital, and with me at council table is Dave Callan.
Thank you. We are being streamed, right? Okay. We've had some technical difficulties in the last couple days, so I have to double check. But yes, we are being streamed live by both audio and video. And Attorney MacLean, if you're ready to proceed, we'd be happy to hear your argument.
Well, thank you very much, Chief Justice Stanfill and members of the court. As someone who has spent the last 28 years in courtrooms around the state of Maine, I can say with confidence that there's something magical about the trial process. Every case takes on a life of its own in the courtroom. Witnesses come across differently from how they may have appeared in deposition transcripts or in affidavits at the summary judgment level. All of us who spend time in courtrooms know that our preconceived notions about how things may turn out are often very wrong. The determination of whether Patricia Spofford had testamentary capacity on March 1st, 2018 is a factual decision. It's a decision made after hearing witnesses testify and after determining the credibility of those witnesses. Summary judgment is not a substitute for trial. The Zanis are asking for the opportunity to present the facts to a judge in the courtroom, for the judge to assess the credibility of the witnesses, and to allow the magical trial process to play out. Keep in mind that in June of 2017, Mrs. Spofford executed a holographic will, leaving all of her assets to my clients, the Zanis. By March 1st, 2018, 9 months later, she executed a will almost entirely disinheriting them. A lot happened in that 9-month gap. In July and August of 2017, 2 medical doctors concluded that Ms. Spofford was suffering the progressive effects of Alzheimer's, that she had severe cognitive impairment, that she was incapable of managing her own affairs or disposing.
Counsel, I see that the green light is on.
Yes, Your Honor.
And I think many of us are actually fairly familiar with the facts in this case, particularly since this is not the first time this case has been here. My question is, this will be a trial in the probate court, right?
Yes, it will.
That's a bench trial?
Yes.
Is the standard the same if we are looking at a summary judgment motion being ruled upon by a judge who indeed is the fact finder in a bench trial?
Well, I don't believe the standard is. I don't believe the standard is the same. I mean, the point I was making at the outset is that there's something different about the trial process.
Well, I understand you may think that there's something different. In this case, the probate judge had the opportunity to, for example, see the video, right?
Yes.
Videos, I guess there are 3 of them.
Correct.
I'm thinking of, I guess what I'm thinking of is when you think about judgment as a matter of law, for example, at the close of the proponent's case in a jury trial is one standard, but the standard is different in a bench trial when the person who's making the ruling on whether as a matter of law the case has been made is actually also the fact finder. Should we have some greater deference to the probate judge in this case when the probate judge is indeed the fact finder in the probate court?
I don't believe you should. I think that it's one thing to read sterile deposition transcripts or affidavits. I mean, the videos that you mentioned were from one point in time, one day, the day on March 1st.
Well, the critical day.
the critical day, but you can't assess the testamentary capacity in isolation from who this person was 1 month before, 3 months before, 9 months before, or for that matter, a month or two later. The law is clear that it's the court is to take evidence from more than that one point in time. I mean, I could imagine scenarios where we have a video of someone, maybe an elderly person, maybe with Alzheimer's, on one day saying, I want to leave all my assets to my nurse, who I've known for the last week, but I think is a wonderful person. But all the other facts from 9 months before, 2 months later, show that this person has severe cognitive capacity, is incompetent, is not capable of understanding the full nature of their assets or the natural bounty of their assets.
And your position is that information from before and after may not be conclusive, but it certainly still should be considered no matter what the video looks like.
Absolutely. And I believe our case law here in Maine establishes that point repeatedly. I don't think that's a point in dispute. And we want the opportunity to be able to do that in a courtroom.
But you have, everybody knows this, but I'll say it out loud, you and your clients concede, we don't have anything on the day of. We weren't there. We don't know anybody else who was there. And it's been teed up, a pile of facts coming from different sources, making a really compelling case for that day. But as you point out, and you concede, the day is the critical thing. We've got a whole pile of cases that say it's the day of, even if before and after there were problems. So it comes to us, comes to the court on basically summary judgment, agreed or statements of material facts, of which neither side really disputes, and you've put in powerful evidence of before and after, although they don't close in on the actual day itself. Right. And I guess my question to you, maybe following up on the Chief's question, is here, on summary judgment, if somebody puts up a case that's very powerful on paper for that particular day there, and you don't have anything to rebut any of that, except that maybe they'd make a bad appearance as a witness, and maybe cross-examination would be better, but the judge and we are left with that summary judgment record, which is powerful evidence day of, nothing else except this stuff out here. Basically, it's an agreed statement of facts, and your argument to us today is a difficult one, saying even though all the facts are agreed, we still should be able to put in this other stuff which may or may not be ultimately relevant, but you can't show us anything beyond that. So I'm taking a long time to ask the thing that everybody is talking about in your briefs, and you're going to today say the reason is that credibility must be assessed in person. So if we buy that, then arguably we'd be in your corner. If the evidence is otherwise compelling on four corners, we wouldn't.
So let me try to answer that in two separate ways. First, my clients were not allowed, were being restricted from access. Their mother was being isolated from them, so they weren't able to be there that day or even the day before or even the week before, because the caregivers were creating hostility between the mother and my clients, falsely saying to their mother that their sons were stealing from them and getting her riled up and creating animosity that was preventing them from having a relationship. That's
was that in your summary judgment? Just I haven't looked at the record in the recent past. Is that in the record that they're being isolated?
It is in the record. It is in the record, Your Honor. The second point I'll make, though, is that our contention is that we do have evidence that goes to what was happening on March 1st, but it's evidence from before and after that show what her mentality is, what her mindset is, what her testamentary capacity is.
So whose credibility would you be attacking or examining? She's dead. You have the videos. So who do you think the affidavits would deviate in any way? The doctor?
Certainly, Your Honor, we would be attacking the credibility of Dr. Dickens, who was her primary physician, who authored two.
But you could have taken a deposition and tried to see how much room there was, shall we say.
Sure. I mean, we believe there's a lot of room because his statements, even on March 1st, seem to be contradictory. He's making a
Well, it wouldn't be contradictory if indeed and this is, we all know, for any of us who've ever dealt with somebody with, for example, dementia, it waxes and wanes.
It waxes and wanes, but it was progressive in nature, and we believe getting worse over the 9 months from when she left all of her assets to my clients in a holographic will to when she effectively disinherited them.
But the doctors in our case law both say someone in this can have moments, days of lucidity.
They can, but just in the example, the hypothetical I gave, a gentleman, an elderly gentleman with Alzheimer's who leaves everything to a nurse who he's known for a week, we don't want to just view what happened in a video on that one day in isolation.
And the problem can be that somebody with Alzheimer's or other forms of dementia and other incapacities can appear rational and lucid even when what they're saying, if you tease it out longer and longer, may not be.
I think that's right, and that's one of the reasons why this court has repeatedly held that we need to look beyond just the single moment in time.
So I want you to put yourself in the shoes of the lawyer on the other side who is representing her. What more could they have done? They took videos of her on that day. They've got medical that says she waxes and wanes. So she asks all the questions. Sounds like it's a good day. Video, video, video. What more could you do?
I mean, Attorney Hollowell did a fantastic job with what she had to work with. I don't dispute the way she approached going about this, but our view is that all of this was orchestrated by the care providers who were hostile to our clients, who were absolutely bent on having my clients be cut out from the substantial.
But we have a
assets of the
video that shows her answering all the questions appropriately.
I mean, I would disagree with that to some extent. She didn't seem to have a full grasp of the nature of her assets. There were times
we've said that the standard's pretty minimal.
I get that. But she's also labile. That's been repeatedly established. She has these flights of sort of reckless decision-making, impulsivity, as I say, severe cognitive impairment. For some reason, she came into that meeting extremely hostile to my client, Michael Zani, who was entirely disinherited, like immediately almost shouting out in the video, "He gets nothing! Michael gets nothing!" As if someone had been speaking to her about Michael and perhaps still falsely suggesting to her that he's trying to steal from her, which was never true, and the record established.
You can speculate to that, but it's not like, as Justice Connors said so eloquently, she's dead. You can't ask her.
We can ask her, but there's a pretty compelling factual record of her not having testamentary capacity. In fact, a probate court found her incompetent just a few months before she executed this will. There's almost an unbroken stream of mental cognitive deterioration.
Well, there was a deterioration, but there isn't any evidence that she lacked testamentary capacity.
Well, she was on 17 medications, Your Honor, at the time she signed this will, including oxycodone, methadone, Xanax, other mind-altering medications that,
Counsel, apart from the opportunity to see and assess credibility of witnesses in person at a trial, is there additional information that you could have presented that you would present at a trial?
I mean, I think the way I would answer that is, I mean, for this argument here, we're stuck with our summary judgment record. But what I would say is, and I think we all know who spend time in courtrooms, that what happens in courtroom, witnesses don't necessarily say the same things they said in the summary judgment record when they testify. Memories are different, the way their charisma is different, their attitudes are different, their credibility can be called into question in ways that maybe aren't developed in a summary judgment record. And that's why we have trials when there is a competition among the facts, when there are competing versions of the truth and the facts. I recognize the lights.
It is. But you know what I'm going to ask? But I guess if we go with what you're saying there, what is the rule? Summary judgment never lies? I mean, you're just basically saying, well, you should see them in person and be able to judge and have the opportunity to see if they really stick to their testimony. Does that essentially rule out the use of summary judgment? We've made it clear that that's not the law.
I mean, summary judgment is not a substitute for trial. If there's a competition among the material fact, if there are different versions of the story, however unlikely one version may be to succeed at trial, your law says we get a trial, and that's what we're asking for.
Thank you. And Attorney Walton.
Thank you, Chief Justice, and may it please the court. It sounds like the court is largely familiar with the case and the issues presented by the appellant's position, and so I do want to streamline my opening a little bit. But I want to lead with a point that I think Justice Connors raised, which is what else could Ms. Spofford have done to prevent the squandering of her estate's resources on a trial? And I think if the court were to hold that conjecture and medical speculation like that offered by the appellants is enough to require a trial, that ruling would have significant practical consequences and would directly conflict with the presumption of capacity set forth in the probate code. And I think that presumption is really important, in part because it abrogates a lot of the court's old case law about these complex evidence or burden shifting, this kind of burden shifting framework where courts were, candidly acting a bit like doctors and trying to determine, well, if this person is acting in this way on, X date, surely they would be acting the same way on a later date. And we don't do testamentary capacity analysis in the same way. The legislature has said there's a presumption of capacity. And so turning back to the thorough record that Ms. Spofford created for after she died, I think it's really important that the court watch the videos. They're in the record. They span, I think, 45 minutes or so. And I think they make this case easy because the videos don't change from the summary judgment to trial. And the same probate court that watched the video and determined that summary judgment is warranted because the record as a whole could not support the appellant's position should be affirmed. And I'm happy to, I see my time hasn't expired, but I'm happy to take questions now.
And then I'll follow up on the last thing you just said. I think that plays a little bit into the question that I asked Attorney MacLean. Given that we know that this is probate court, that it's a bench trial, and that the same judge is looking at this video, who is indeed the fact finder, does that mean the standard is a little different on summary judgment, that we give a little more deference so that even if there arguably is a fact question, given that this is the judge who would make the determination based on this video?
I think the answer that Attorney MacLean gave is probably right, that in cases where it's mostly about testimony, I think the standard maybe shouldn't be different, but in cases where there is direct video evidence, and I can't really overstate the importance of the video to this case,
Okay.
in part because it is the best evidence.
Well, then let me move to what my concern is with this. What is the holding? And let me be clear. So if we say there's no fact question here, what if there was someone who saw her an hour before and said, oh my gosh, she didn't know me, she didn't know who she was, she didn't know what was going on. An hour afterwards, she didn't know me, she didn't, she sounds really good when you see her, but then when you talk to her, you realize she's talking about green men on the moon. At what point, what is the holding that you would ask us to make if that evidence isn't relevant? Are we saying simply, well, if we have a doctor, an attorney, and a video that says it's good, it's good?
So I think it's important that the day of is really important. And I think what's really critical and what's missing from appellant's case here is if there is this video and medical evidence relating to the day in question, there needs to be some medical evidence tying whatever happened,
So is that the holding, that absent medical evidence, you win as a matter of law?
I think that could be the holding. Obviously, it's the court's
Well,
prerogative.
no, this is a serious question. I'm not really sure how you phrase a holding. With all the case law that we've had that said, I understand a lot of that's in the context when there wasn't direct evidence of the person's capacity or, necessarily on that day. But still, we have said time and time again that evidence, before and after can certainly be considered in determining whether or not that person has testamentary capacity. Are we throwing it out?
I'm sorry, Your Honor, are you throwing out that old case law?
Yeah, we've said the appearance at moment of execution is not sufficient. You have to consider the behavior over a period of time. And we've got a lot of law out there. And I understand how compelling the evidence is here of testamentary capacity, but I'm trying to figure out what's the holding? What are we saying?
So I think the presumption of capacity set forth in the probate code does a lot of the work to deal with that old case law. It's not, you don't need to overrule it. It may have been correct when it was decided, when it was a common law system, but now the legislature has
So we're
said-
not going to consider evidence on either side before and afterwards?
So I think if you are, that evidence needs to be tied to the actual time of execution of the will, usually I think through medical evidence. But
So you're backing back around to saying that, we got an attorney, we got a lawyer, we got a doctor, and we got a video. That's good enough. We don't have to go any further.
Well, I think my position is it's just a straightforward application of the summary judgment standard, which is the record as a whole can only support one outcome. And this does kind of bring me back to something I think that...
Counsel, before you go there, let me ask you this. Medical evidence meaning another doctor's opinion about the decedent's behavior on the videotape? Because there's ample evidence, medical evidence here to suggest that she has a progressively deteriorating condition. So I'm not sure how the presumption works, and I'm not sure what medical evidence you're talking about.
So I think Justice Douglas, you're exactly right, that it would be it would be an opinion based on the evidence, and there is, as the court knows, extensive direct evidence from the day in question. You have Dr. Dickens's examination and notes of what her symptoms were like. You have the video, which I won't go into. You have other witnesses describing what she was presenting as, and I think it's not impossible that a doctor could look at that evidence, at that, those other data, and reach a different conclusion. And in fact, that's what the appellants tried to do here. They designated, I think, at least 2 experts who were going to testify on testamentary capacity. One of them, Dr. Voss, was ultimately deposed, and he testified that he had viewed the video and that he was not going to offer an opinion on testamentary capacity. But
at page 9 of its decision, appendix 19, the court said, and I quote, "The evidence the Zannies have produced is certainly admissible. That's the evidence of her condition on days other than the date of execution." Back to the quote, "But it does not generate an issue of material fact in light of the uncontested facts on this record." End of quote. Is that really the key to this? Meaning that the material fact at issue is her condition on the day of execution, and evidence on other days is certainly admissible, as the court said. But the question for us is whether the court erred in determining that that other evidence did not raise a genuine issue of material fact as to the date of execution.
I think that's exactly right, Justice Horton. That the question is not whether the evidence offered by the Zannies is admissible. I mean, I could imagine the Zannies testifying in court, yeah, we spoke to our mother 4 months.
Well, and all the other medical evidence about her over the course of the guardianship and afterwards.
But both of you have referenced the videos. Are you suggesting that we, as an appellate court, should watch the videos and draw our own decision as to whether or not she has testamentary capacity?
Yeah, what if we don't think she does?
Do we have any business as an appellate court watching the videos themselves and for the purpose of drawing that decision?
So I think it's a nuanced question, and I don't think this court has addressed.
It's always a good way of putting it. It's a nuanced question, yes.
I'm asking you, are you asking us to watch it?
So I am asking you to watch it.
To draw our own conclusion about testamentary capacity?
In the context of the entire record, yes, and I think that's where the difference between...
So be careful. Are we going to start watching all of these days? There's a lot of video evidence and other kinds of evidence that we could make our own conclusion. Are we going to overrule trial courts when we see the same evidence?
So I think the standard has to vary between whether it's at summary judgment or after trial. If it's after trial and the trial court has viewed the video and also heard testimony, then it's still a clear error standard, and you would apply that standard, and maybe your perspective on the video might be different. But if you don't feel that the trial court clearly erred in viewing that video in light of the other evidence, then you would affirm. At summary judgment, I do think it's de novo, but it's still on the record as a whole. And the other point I would make that one of you made, and I apologize, I don't remember who it was, is that this would be the same probate court that adjudicated all of the guardianship proceedings.
And that court's already seen the video once, right?
Correct.
I mean, that's sort of the practical background here, is it's going to be the same judge making the decision.
Yeah, and I don't mean to be too lofty, but I think at its best, summary judgment has an important benefit of conserving judicial resources as well as the parties'
Well, and that's why I raised the difference in standard applied to judgment at the close of the plaintiff's case in a jury trial is a different standard than in a non-jury trial. Because when a non-jury trial, the judge is actually making those determinations. And so I didn't know if there might be a different standard on summary judgment as well when we know it's going to be the same judge at a bench trial.
We are not taking the position about that. If the court want...
Another left field question, huh?
Well, so if there's evidence, is the difference here, because if there was evidence that she lacked testamentary capacity the day before and evidence the day after that she lacked it again, that could raise a fact question. But the medical evidence never, until your doctor, it says, yes, she has dementia, all these things, but it never says such that she wouldn't have testamentary capacity. So that's unrebutted on that specific issue. Is that a relevant point to observe?
I completely agree that that is a relevant consideration. All of that other medical evidence, as well as the guardianship and conservatorship documents and petitions, are about a different issue. Guardianships are about whether a person has the capacity to, take care of themselves in the real world. Conservatorships are about a person's capacity to manage sophisticated financial matters. Testamentary capacity is just a very low, do you understand the rough scope of your estate and who you want to give it to? The last thing I did want to mention in response to your question, Justice Connors, is I don't think... You started your question say there's evidence of a lack of testamentary capacity on the day before. I still think you need something, and I think often it'll be medical evidence that links to whatever the person's capacity was like on the day before to the day of. And I think that's a critical piece that's missing
So
here.
you would need, even in that circumstance, you need a doctor, for example, saying, on this day she lacked testamentary capacity, and given the nature of her dementia, it is unlikely she would have capacity the next day.
I think that's I think that would suffice. but that hasn't been opined here. Unless the court has anything further. Oh,
Thank you.
thank you.
Attorney MacLean, is it significant in this case that it's actually the same doctor who examined her on the day of execution and testified by affidavit that she had testamentary capacity? It's the same doctor who issued the PP 505, who recommended a conservatorship, who saw her most immediately before and who saw her most immediately after.
Well, what's interesting is that the trial court, in ruling against us on summary judgment, had to make a credibility determination about whether to accept effectively the opinion of that doctor based on what was written in the doctor's affidavit. The court might not accept that doctor's testimony if we have a trial.
Well, I'm not following.
I'm not either.
I mean, somebody files an affidavit, there it is. I mean, how did the court then make a credibility finding?
Well, what I'm saying is that during the trial, we would be attacking that opinion, and we would be attacking it by the
Yeah, but you
prior
seem to be
conclusions.
arguing that that you should have a trial in every case and we should never give summary judgment.
No, I mean, summary judgment is very effective making determinations when the facts only support one legal conclusion.
But my question went more to the fact that it is the same physician before and after who raised questions that you would rely upon about her ability to govern her affairs, who said basically, despite that, on this day, she had testamentary capacity. I mean, I think you'd have a stronger case if it was a different doctor.
I mean, I actually disagree. I would be attacking on cross-examination how this doctor's position could have dramatically changed given...
Well, it's easy to answer. No change. It's just that she has periods of lucidity despite the progressive.
Although the medical records don't seem to support that.
May I ask one more?
Go ahead.
Do you want us to watch the videos?
I mean, if I say no, it's not that I want to try to keep you from seeing the videos. I mean, they are what
Whether
they...
you think we should or shouldn't as an appellate court?
No, I don't think you should be watching the videos and making independent conclusions.
Okay. Thank you. Thank you, counsel. Thank you for the argument. And as is our usual practice, we will take the matter under advisement and issue a written decision in due course. As is also our usual practice, Attorney Walton, this is your first appearance live in front of us, and we would welcome all counsel to come back and take the greetings of the court.